Okay, our second and final measure is AB 1521 by the Assembly Committee on Judiciary. Senator Stone, we've been chatting and look forward to the presentation, and to reiterate, 2 witnesses on each side, 2 minutes each, with everyone else just stepping forward and identifying their name and affiliation and their position on the bill. Good afternoon,
Good afternoon.
Assemblyman.
Thank you. Senator Stone's the other one, so
Assemblyman.
I appreciate that.
I thought I said. I started off Senator, but I thought I caught myself.
We get
obviously
each other's
not
mail,
well
so
enough. That's right.
Yeah,
that's right.
That works out.
Assemblymember Stone, please go ahead.
Thank you. Thank you. This bill 1521 comes from a long conversation with all the stakeholders around the issue of ADA access and the lawsuits that have been generated in California around them. And what became clear was that there were just a few parties that were doing pretty much most of the litigation here in California. And in order to make sure that we are focusing on good ADA policy, getting access issues addressed, making sure that all Californians have the access that is guaranteed them as their civil rights, addressing the abusive parts of the process is what this bill is about. For the bills that came through Assembly Judiciary, we talked with a lot of the authors about including some of these components, negotiated many of the components, negotiated with the bills as they went through. And what was left were some issues that we felt needed to be addressed. Most specifically, when a plaintiff is filing a suit, then what we would like to see and what this bill provides is more information given to the defendant about what they're to expect, what the level of potential liability is, and that's the judicial forum part of it, so that we're working between the plaintiffs and the defendants and getting good information to, these are mostly small businesses that are bearing the brunt of it. And unfortunately, many of the small businesses react to a letter, react to a lawsuit that's been filed with a great deal of consternation, are very happy to write a check to maybe make sure that it goes away, without understanding the depth of what defense they may or may not have, or even their obligation to just to fix the problem or have fixed the problem before we get there. What we're also doing in this bill is identifying high-frequency litigants and the attorneys who are the high-frequency filers. And we've been working very closely with the disability community, with ACLU, with all of the stakeholders in it, with the supporters of the bill that you'll hear from today, to help kind of frame and define. We're not completely settled on those definitions yet. I think we have agreements in concept, but are working on the language. And what's before you today is the bill in chief. The amendments will be taking up as it moves into appropriations and onto the assembly floor. And I want to tell you right now, as I told Senator Leno a little bit earlier, I think that this is important policy. I think it's an area that we need to address, and it is ripe to be addressed now. We are close enough with the amendments, but I will not, as it gets through appropriations and gets to the floor, I will not take it up on the floor until we've had agreement around these amendments, that we've worked with committee staff and members of this committee to make sure that you're comfortable with the level of the agreement we have. As I said, I believe we have agreement in concept, and what we're trying to do is make sure that we're limiting who this is applying to, those lawyers and those plaintiffs, to make sure that we're truly after the bad actors. Get that business practice of extorting small businesses off the table and change that, really change that behavior. I know this is kind of moving through the process. It's a little bit in flux, as a lot of legislation is this late in the year. But it's an important issue. We're right on the cusp of really being able to settle this down. So I'm asking that this bill be moved out of committee today, and you have my commitment to work, make sure that each member, the chair, and the judiciary staff are comfortable with the amendments that we're making along the way. The analysis was very in-depth and was pretty spot on with the tensions that we're trying to deal with here. It's a small number of small businesses that get caught up in it, but it creates for our constituents a great deal of angst when it's not clear. We don't have any regulatory oversight of the ADA laws. It's left to the civil justice system. That's why we're here, to tweak that system and make sure that it will work as effectively as possible, not unduly get businesses caught up in it. But the primary goal always is and has to be that we're ensuring that businesses come compliant with the ADA, that fix the problems before there's any issues that get raised. We want to make sure that those incentives are there so that businesses aren't making a business decision about when to address the ADA issues, but are making sure that they're addressing those issues up front. Senator Roth's bill is now in the Assembly. It provides for much of those steps dealing with the CASPs and in ensuring that the right incentives are put in the right place. This bill is meant to address that relationship between the few high-frequency litigators and litigants and their effect on the small businesses. And as I said, change that business practice and make sure that lawyers and plaintiffs are going after businesses that they need to, with the result of getting access issues actually addressed and fixed throughout this process. So I have witnesses here in support that I'd like to ask to speak. And with that, I respectfully request your aye votes.
Thank you very much. Good afternoon.
Good afternoon, and thank you. I'm Nancy Pepperini on behalf of the Consumer Attorneys of California in support of the bill. In a nutshell, unique circumstances call for unique responses, and that's what this bill does. Consumer Attorneys is trying to find a solution that to a problem plaguing many California communities, and that is how to make buildings more accessible, but at the same time stop the abusive practices of a small handful of attorneys who are seeking fees and not compliance. We view both of these problems as significant and deserving of a solution. While Senator Roth's SB 251, which passed the House in June, addressed the issue of providing incentives for business owners to hire access specialists, this bill addresses the other very important component: how to negatively affect that business practice, that business model of the group of attorneys who are suing mostly small businesses and not seeking compliance. And that's not the purpose of the statute. This bill attempts to distinguish the bad actors who are motivated by quick settlements from the good actors who represent folks with disabilities facing insurmountable barriers to accessing California businesses. The major distinction really is the number of complaints being filed, and I think that's an indication. The top 10 plaintiffs from January 2015 through January 2015, each 13 to 15, each filed anywhere between 77 to almost 300 disability suits a year. And this bill will have minimal impact, if any, on plaintiffs who aren't the high-frequency litigants. I kind of did a little survey among our members who, do very good work helping people with disabilities in these cases. And I think the answer that I got back was that I don't think any of those attorneys file more than 20 lawsuits a year. So really, you go from 20 to almost 300, something's wrong, and it needs to be addressed. And I think this is a narrow approach. Let's try and get at that business practice. So we are in support of the bill. Thank you.
So just for clarification, if I may, what your objection is to attorneys who are filing a number of these cases are that they're not seeking compliance as part of it. Is that correct?
That's correct. I mean, what we're it's hard to every case is different, but what we're troubled by is where there are suits filed, and some of these attorneys will demand a settlement fee, but there's nothing done to ensure that there's any compliance in the building. It's so that the purpose of that lawsuit is met.
So if they were to file suit, if you had attorneys, and there are some who specialize in certain areas of law, who did file a number of these cases, because we know there are many circumstances out there where the ADA is not being complied with. If in the process of bringing suit, they were also to seek and force compliance, would that be a different, let me put that, would that take away what you believe is the need to have this kind of prohibition against plaintiffs' attorneys who file these cases? Is that the real problem?
Yeah, and I think some of the amendments that we've been looking at address that situation, because and again, it's still fluid, but as I understand it, the amendments look at not just the number of complaints filed, but yet whether or not there was some remedy that was accomplished as a result of that lawsuit.
Well, I know it's a little not quite a form, but we've been talking about this, and that really is the gravamen of the problem to me, is I don't think we should be limiting the number of lawsuits attorneys can file who have a specialty in a particular area, as long as they're not shakedown lawsuits. And a shakedown lawsuit, to me, is one that defines using the problem as an excuse to extract money without attempting to resolve the problem. And it seems to me that in this case, and I'm glad to hear some of the amendments you're looking at and the commitment from the Assembly member that this is something we really need, I think, to address before we go forward on the floor, if you will, of this with this bill, is to try to figure out a way how we can get compliance or efforts. You know, you get a settlement on a case. It isn't all what we're hoping for in these cases. It's not really all about the money, or it shouldn't be all about the money. It should be getting compliance so that people, companies comply, property owners and businesses comply with the ADA. That's the goal. And if there's some way we can, if there are aggressive firms that sue and there actually are violations of the ADA, the goal is to get these companies to comply. The basis of the lawsuit, the basis of the law is really to get compliance so that people with disabilities are able to access what the rest of us are able to access. I mean, is that in essence what the problem is that they're taking the money and running and they don't care if there's compliance? I mean, what is the reason, in your opinion, for this legislation?
Well, I think we agree with everything you just said, which is the goal of any disability access lawsuit should be compliance. And the problem is, and it's, you read any newspaper lately, especially in the Central Valley, and particularly some hard-hit areas where there's a handful of attorneys, and I think the statistics bear it out. There are a number of attorneys who are filing high numbers of lawsuits, and those are the ones who show up in the newspaper and who, a couple of them have been disbarred, but it's not enough. But what they're doing, to our understanding, is filing these lawsuits, and what I've seen the letters that and the demand letters, they'll usually settle for anywhere from $5,000 to $20,000, and then they get their money, and it could be a plaintiff who is routine. There have been instances where there have been plaintiffs that are used over and over and over again, and it's been physically impossible for them to visit that many businesses in that one day, just geographically speaking. So it's a limited amount. We really think that the purpose of any lawsuit has to be access compliance, and we're fully supportive of that. That being said, I think we have to figure out a way to address that small group of lawyers who are not seeking compliance.
And I think we're all in agreement, or I'm assuming that that's the reason that we're here, is that we want to, there's a small group of bad actors, and this again brings back that memory of the 17-200 cases about a decade ago.
Yes, it does.
We not only disbarred those lawyers, they went to jail, which seemed like a very appropriate, they were shaking down small businesses, I believe, particularly in Orange County, that were being run and owned by immigrants, I think primarily from Vietnam, really taking advantage of a vulnerable population. And I think that there's always an exception. There's an occasional bad actor out there, but it seemed to me that we were able to resolve that problem in a way that didn't undermine what the intent of the law is. And I hope that we recognize, and I'll be interested in the ADA witnesses, that really we want compliance here. So you mentioned a couple things, the disbarment. I have no problem with disbarring those bad actors. Also, you mentioned trying to find a way to assure that compliance, and that the amendments that you're looking at are looking at some of these alternatives. So I would be interested if there are any others that you're suggesting, and what we might do to make this a bill that does what everyone is hoping it will do. And I, as I say, I appreciate the Assemblyman has been working hard on this. I know you have. I know we all want to see the right thing happen. It's just a question of how we get there. So I apologize for interrupting, but this is really, I think, to me, the gravamen of the issue. So with that, second witness.
Catherine Pettibone, Civil Justice Association of California. We have a supportive amendment position. We are supporting for many of the reasons. The same thing. We actually do ADA workshops where the first thing we're telling businesses is you need to know the law, you need to comply. This is important for all of us because this has been the law for 20 years. You need to know what the requirements are, and so we think a lot of the provisions in this bill are going to help. There's a lot of new pieces that are educating businesses that have. Are informing people that it actually puts clear about how to contact the state bar if a plaintiff's attorney isn't doing the right thing, and those are really laudable things. Our concern is with Section 1 regarding the contractual provisions, and we've had good dialogue with the author's office on that. We are very concerned about mandating immediate liability when parties can contract around it. They may not have knowledge about what's going on the premises regarding landowner and leasees, and so we're working with that with the author.
So are you, so I'm clear, are you supporting that there be, you talked about education, and I think that's critical because a lot of, particularly these small businesses, first of all, they don't know that they're supposed to be ADA compliant, or if they know that, they assume that as tenants that the landlords have taken care of it. I know that landlords, in some instances, not all, will try to push the liability onto the tenant to make the repairs. And there's a lot of, a lot of problems associated with the compliance on that level. You're talking about education. I believe that probably the purpose of that first section was to sort of clarify responsibility for ADA compliance. Are you prepared to continue working on that, or what is your position?
We're definitely open to working on that. We were worried about the contractual mandating of liability, but certainly the education piece is important. So we're definitely open to working with it. That is our area of concern with the bill, though.
Is the contractual mandate? Mm-hmm. What do you?
Ideally, we'd like to see that removed and have an educational component part put into maybe leases, or we haven't even gotten into it. But at the moment, we'd love to see it out. But obviously, open to continuing to see what that looks like.
But the contractual mandate requires that somebody, either landlord or tenant, takes responsibility for compliance. Yes. What is that?
This is saying that it automatically goes to the landlord. Yeah.
Okay, thank you very much. Next witness.
Dean Hutchings with the California Grocers Association, aligning my comments with my colleague from CJAC, looking forward to supporting the bill if amended with regards to Section 1.
And again, you don't want the landlord to have liability, to have to do the compliance. Is that your?
Well, most of our members, some of them sublease and some of them do own the property, but would like to continue working with the author to further that conversation. So
would you like to see this a negotiated part of a lease, or what is it you're looking for?
We would like to leave it to the parties to negotiate, for sure. I mean, if parties contract with it, that's up to them. We're concerned about the constructive knowledge aspect. If something happens, I know in the bill it has knowing, but again, we like to leave that to the parties to contract. So it's not something that we're saying there should be somebody sticking their head in the sand, but we are concerned with starting to interfere with contracts on that.
So would you be opposed to that being at least one of the paragraphs within a lease, so that at least landlord and tenant know that there's a question of ADA compliance?
I think we would be open to something.
Okay. Just a question. Thank you. Thank you very much. Since I sort of broke my rule here, are there any questions that anyone has before you leave of the proponents of the bill? Senator Anderson.
I didn't know if you took in consideration how quickly, too, that these rules change. So you may come out and paint your lot, but there might be something about the paint color, could be about how it's painted, it could be all these things. They change rapidly all the time. Unfortunately, in this process, it'd be great if they said January 1st or every quarter, these rules are going to go into place so that a business owner or a property owner could go back and say, okay, I know I have to have this done by this date. But a lot of times that stuff changes rapidly, and they think they're compliant because they were compliant yesterday, but the rules change today. And so we're forcing a lot of folks to go out and purchase memberships and services where they do nothing but monitor this and give them updates all the time. And, you know, I think our goal is an admirable one. Everyone should have access to products and services. Everyone should have access to travel anywhere in society. And I want to see that happen. I just think that we have to be very thoughtful in our approach to make sure that that's the goal that we're achieving and that people aren't profiteering off the backs of hardworking Californians who want to do the right thing. So I thank you for this bill. I want to encourage you to continue looking at all the different elements, because I think that one size doesn't fit all. I think there's a lot of items that are occurring, like what I just described, that when you talk to the business owners, when you talk to the folks, it's really enlightening and rather shocking, because these are people that want to comply, and they want everybody to have access to buying their products and services. So thank you very much for your efforts.
Well, thank you, Senator. And a lot of that is beyond the scope of what we're trying to do here, but the piece that is relevant is the notification we're asking the plaintiffs to give to the defendant, because you might have a situation where the property is legal non-conforming, and yet due to confusion or lack of information on the defendant's side, they may not know that. So trying to increase the amount of information that happens when an ADA suit is filed is the goal here.
Thank you. Any other questions, or you can also defer until after the opposition steps?
Yeah, I'd like to hear the end.
All righty, very good. Thank you very much. Other witnesses in support, if you just step forward with name, rank, and serial number, would be. Please, we have a microphone. If you, are you in opposition? Okay, very good. So let's have the opposition step forward.
Good afternoon, Madam Chair and committee members. Jennifer Barrera on behalf of the California Chamber of Commerce. We kind of have a similar position as the supportive amended, but we're opposed unless amended, given the landlord-tenant liability language in the bill. I just want to address a couple of points that have been raised in the discussion, if I may, as a part of my testimony. I believe that in SB 1186, and I have individuals here who were certainly a part of that negotiation, there was a provision included in that bill, the Senator Dutton, Senator Steinberg bill, several years ago that specified that a landlord had to identify in the lease whether or not the building had been CASP inspected, so that the tenant was on some type of notice as to whether the premises had been inspected. I think we are too open for negotiation and discussion on that issue. It's been a continuing issue on this debate for the past several years. It's not something that is new to the table, I would say. But I think mandating specific liability onto a party in a contract is interfering with the contractual relationship of those parties, and we're not supportive of that idea. But again, certainly open to that discussion and have had discussions on this issue as this bill has been moving forward. So we are opposed to the current version of that bill. Honestly, I don't even think that it adequately addresses it in 1521 right now, the landlord-tenant issue, given some of the language issues, but that is our opposition. And then just to the chair's point about whether or not simply applying this to plaintiffs' attorneys who are only seeking settlement or monetary amounts and not actual relief to remedy the construction-related accessibility claim. We, too, want to encourage accessibility, and we believe that should be, of course, the forefront and goal of any of this legislation. But we have concerns with just mandating that this is only applicable to those who don't seek remedies or like remediation of the construction-related problem, because certainly you can allege that in your complaint, and you can certainly amend your complaint thereafter to eliminate it. So I think we need to be careful so we don't open up a loophole and allow a plaintiff's attorney to kind of game the system and simply allege that they're seeking injunctive relief or some type of cure, and they actually don't fulfill that request. So that's our concern on that end, and we are opposed unless amended. But I want to thank the author and his staff who have worked on this bill to address a lot of our concerns, and this is the only remaining issue which they have agreed to work with us on that issue. And once that is addressed, we would remove opposition to the bill. Thank you.
Thank you very much. Other witnesses in opposition? Good afternoon.
Good afternoon, Madam Chair and members. Kevin Baker for the American Civil Liberties Union.
We also have been working with the author. We're supportive, in contrast to our brothers and sisters in the business side. We're actually supportive of the author's efforts on the landlord-tenant issue. The folks that Mr. Anderson are concerned about, the small business people, are actually at quite a disadvantage in negotiating those agreements. We think there should be some good baseline rules. Our concern has to do with the inclusion of attorneys in the definition of high-frequency litigant. We think it's unprecedented and improper to conflate lawyers with litigants and then subject those lawyers and their cases to different procedural rules based on the fact that the lawyer might have, as the chair indicated, an active practice in a specialized area. Nevertheless, we think we've had some fruitful discussions with the author's office, and we are confident that the amendments will be able to remove our opposition. Thank you.
Thank you. And on behalf of the disability community, why don't you go ahead and give us your view of the bill?
Evelyn Abu Hassan with Disability Rights California. I want to concur with many of the comments that Mr. Baker has made. We are working hard to address the issues, assuming we can come to an agreement. We'll continue to work with the author. We conceptually are, I think we're close. You know, the biggest concern for the disability community is that this is the primary way we make sure that we have enforcement of our civil rights. And we want to be able to do that and make sure that we have access just like everybody else. Like I said, I think we're close. We'll continue to work and hopefully be able to get there. Relative to Mr. Anderson's comments about businesses and the laws changing quickly, you only have to come into compliance with the laws that were in effect at the time that the business was constructed or dealt with. So we want to be clear about what that is. So if the building was constructed in 1996, you look at the laws that were in place at that time. Just to clarify.
I think we sometimes refer to that as grandfathering.
Correct.
Yes. Okay, thank you. Good afternoon, quickly, if you would.
Randy Hicks, California's Disability Rights. We concur with everything that's been said by the ACLU and DRC, and we'll continue to work on the bill.